I'm making my YouTube video for chapters 9 and 10 of legal reasoning or legal argument. Class is legal reasoning, but this is the book. I just wanted to show it. Yeah, I'm going to be reading out of this because I don't know all of the facts of the case off the top of my head, and I'm going to need to read out of it. But before we get into this, I wanted to get into chapter 9 talked a little bit about IRACing. I think it's a helpful tool. I learned it a while ago. I think it could be a helpful tool for you. And so I wanted to just touch on that before I got into it. And then, of course, after I talked to you about IRACing, I wanted to talk to you about just a few definitions, just so when we do get into this, you understand it a little bit more. So IRAC is issue, rule, application, and conclusion. So the issue is always the precise question that the court must answer. The rule is always a controlling authority. So a statute, a case, application will always be your facts to rule analysis, your prong tests, and then conclusion will always be the result you want the judge to reach. I'm sorry I went over this a little bit fast. I have a short amount of time, and there's a lot we have to get into. This was kind of a meaty chapter. Okay, and then definitions. I do have them over here. I'm just going to read them off to you. Discovery. So discovery is something that both parties must meet. It's a pretrial exchange of interrogatories, productions, depositions, and admissions. Prejudice is the second prong in our case that we are going to be talking about, but in general, it is concrete hardship, so anything that you can prove. So extra discovery, new cost, delays, anything of that sort, all of what our case in here talks about, but this is when a new claim arises after you already closed your discovery. So keep that in mind. And then something I wanted to add was conjunctive versus disjunctive. It talks briefly about it. I think it's helpful to know the difference. Conjunctive is what the case we're going to be talking about it's where two prongs must be met or must be satisfied, and then disjunctive is where one prong must be satisfied. So I thought it was just helpful to get that out. So if we go into the facts of our case, it's Alice King. We are defending ETC, Eastern Tool Co. She was fired because she was incompetent, but she's stating that it's because of gender discrimination. So both discoveries had been completed. Ours was completed 20 months ago. She had also completed hers. It doesn't really give a time frame for that, but it says that she, in the last 2 years, had not asked for extra discovery at all. She hasn't asked for new evidence, nothing. And then it also goes into she did not move to set the court to set the trial date, and now she is trying to file a motion to amend her complaint, her original complaint of gender discrimination. She now wants to add in new claims based on fraud and breach of contract. She only offers one explanation, and King offers that further review of the law and facts shows that the plaintiff has additional state law claims in fraud and breach of contract. So, now this kind of talks about, the book goes into talking about the law. We don't have time to really go into all of that. So, if we're going into the argument, let's do that. So it talks here that we obviously want the plaintiff's motion to be denied. We are defending the defendants in this case, ETC. And then they're under Rule 15A. It's a federal law for gender discrimination, and I think it's for gender discrimination. Let me go back. Let me make sure I didn't just lie to you. Anti-discrimination law, yeah. It's federal, yeah. And then you want to prove that granting plaintiff's motion would unduly prejudice the defendant, who you are defending. The plaintiff has offered no excuse for her delay in moving to defend, so she cannot prove why she needs this. And if the plaintiff's motion were granted, defendant would have to conduct new discovery. These are all things that you want to bring up, all things that you want to prove, and you will win, or it will help your case greatly. So it kind of goes into different sets of syllogistic reasoning that we talked, or syllogisms. I'm not going to go into all those because I'm almost at my time limit anyway, and this is going to drag on if I do not hurry up. So It also talks about a couple different cases, but we're just gonna go into and talk about the bare bones, the meat of it. What is happening? So basically, when we get into our two-pronged test, we want to prove that she has no excuse for the delay and that it prejudiced the defendant. We talked about these terms. We talked about discovery. Both of them had met. Ours 20 months ago. Hers a while ago. It doesn't really state when, but she hasn't asked for anything in 2 years. That's what we know. Well, the book cites Island Creek, and it says that the only valid excuse is new evidence. That's what Island Creek says. So using that as your cited, as your rule, yeah, that's what you're going to do. You're going to use that as your rule, and then you're going to show that further review equals new evidence, which means that her excuse fails because she is forcing you to do extra discovery. Okay? It's also going to cause delays. It's going to cost you more fees, you know? And then you could also cite Hayes here, which is prejudice exists when the adverse party must defend new claims after discovery is closed, which happens here. We have closed discovery 20 months ago, and if we were to have to do this, or she were to add this in, then we would need fresh interrogatories, depositions, and it would cost us money, and we would be delayed. So on her original claims. So again, conjunctive is what this is. Both prongs must be met to deny leave. That's Manzoli. And because both are satisfied here, the motion should be denied. That was our argument. I hope I went over it in a way that you guys can understand. I am short for time. I'm already at 7 minutes. It's supposed to be 5 minutes long. So basically, you want to say, like, the defendant respectfully moves to deny the plaintiff's amendment. You want to state that up front. You want to be very clear about it. Our professor even says you never want to bury your conclusion. You always want to keep it front and center and flesh out the analysis. And so you're going to kind of want to do like a little roadmap for the judge, you know, because the amendment is untimely, lacks a valid excuse, and will prejudice the defendant. The court must deny the leave. You want to quote your rule 15A, and you want to summarize the two-pronged test by Manzoli, and then you're going to want to use your application. Again, I'm going in Iraq for you guys to understand. That's why I talked about it in the beginning. Your application, you're going to walk through each prong with the facts above that we had stated. You're going to insert your citations, Island Creek, Hayes, all that good stuff. Those are persuasive supports for you. That's what you want to do. And then your conclusion, you're going to restate your request. Again, you don't want to bury it. No new facts needed. And that's really all I have to say. I hope that it is understandable for you. I hope I did a good job. And thanks for watching. Bye.